Vote Buying is an Election Offense. By Elaine Ann Bernardino. As the May 2022 national elections fast approaches, Filipino voters should take this time to intelligently consider which candidate has the most promising platform, the ideal character and relevant track record to better the country. Political candidates have only less than a month to campaign. Since a clean and honest election is indispensable for democracy to flourish, political candidates are expected to use lawful and honest means to convince and woo voters to vote for them on election day. Election offenses, such as vote buying, are evils that obstruct the election process. They destroy the sanctity of the votes and abet the entry of dishonest candidates into the corridors of power where they may do more harm. Commission on Elections vs. Honorable Lucenito N. Tagle, GR numbers 148,948 and 148,951-60, February 17, 2003. Section 261 of Batas Pambanza Bilang 881, or the Omnibus Election Code of the Philippines, provides that vote buying is an election offense wherein a promise or a gift is given in exchange for voting for or against any candidate. Any person found guilty of vote buying or selling shall be punished by imprisonment for 1 to 6 years, disqualification to hold public office and forfeiture of one's right to vote. In addition, any political party found guilty would also have to pay a fine of not less than 10,000 pesos. In the case of Nolasco vs. Cumlic, GR numbers 122,250 and 122,258, July 21, 1997, the Supreme Court affirmed the decision of the Cumlic to disqualify a candidate on the ground of vote buying by giving away pay envelopes with money and the inscription stating vote Tinoy. The Supreme Court ruled that while the giving must be consummated, the mere act of offering or promising something in consideration for someone's vote constitutes the offense of vote buying. It is noteworthy, however, that in the case of Lozano vs. Uric, GR 94521, October 28, 1991, the Supreme Court held that the traditional gift-giving of Makati during the Christmas season is not considered vote buying, since it does not sufficiently establish that respondent was trying to influence and induce his constituents to vote for him. Under the 1987 Constitution of the Philippines, the Cumlic has the power to prosecute cases of violations of election laws, including acts or omissions constituting election frauds, offenses and malpractices. The initiation of a complaint for election offenses may be done through a complaint by a party or motu proprio by the Cumlic. Furthermore, it is the regional trial courts that have exclusive original jurisdiction to try and decide any criminal action or proceedings for violation of the OEC, except those relating to the offense of failure to register or failure to vote, which shall be under the jurisdiction of the metropolitan or municipal trial courts. In the case of Cumlic vs. Aguirre, GR 171208, September 7, 2007, the Supreme Court ruled that, while BP 129 vests in the municipal trial courts, metropolitan trial courts and municipal circuit trial courts the jurisdiction over criminal cases carrying a penalty of imprisonment of less than 1 year but not exceeding 6 years. Following Section 268 of the OEC, any criminal action or proceeding for an election offense which bears the same penalty, with certain exceptions, falls within the exclusive original jurisdiction of the RDC. Therefore, in the case of Cumlic vs. Nuana, GR 132365, July 9, 1998, citing the case of Alberto Naldeza vs. Judge Juan Lavilles Jr. AMMTJ 94-1009. March 5, 1996, the Supreme Court held that the Cumlic has the exclusive power to conduct preliminary investigations of all election offenses punishable under the OEC, and the RDC shall have the exclusive original jurisdiction to try and decide any criminal action or proceedings for violation of the same. Moreover, it is notable that Section 28 of Republic Act 6646 provides that a complaint for vote buying or vote selling supported by affidavits of the complaining witnesses attesting to the act of vote buying or selling shall be sufficient basis for an investigation to be immediately conducted by the Cumlic. Hence, in the case of Bernardo vs. Abalos, GR 137266, December 5, 2001. wherein the petitioner's complaint expressly stated that no supporting affidavits were submitted by the complaining witness to sustain their charge of vote buying. The Supreme Court ruled that the absence of such supporting affidavits shows the frailty of petitioner's complaint, hence, the complaint should be dismissed. Vote buying is a serious election offense. Everyone should be reminded that there is no price for the future of the country and that we should all vote wisely.